Good morning, Chief Justice. Good morning, members of the Commission.
How are you this morning?
I am fine, thank you.
Thank you. Thank you very much for availing yourself for consideration for appointment to the Supreme Court of Appeal. And thank you for coming to this interview. I will ask you some questions, and then I will give the opportunity to the head of the Supreme Court of Appeal to ask you questions. She will ask you more questions, and thereafter I'll allow the minister and other commissioners to put questions to you. The questions that we'll put to you are aimed at determining whether or not you should be appointed to the Supreme Court of Appeal. And there is nobody here who just wants to treat you unfairly or in any way. You will be treated with courtesy, but you will be asked difficult questions if there are difficult questions that must be put to you. You understand?
Yes, I do. Thank you.
Okay, all right. Now, we have a lot of information about you which you have supplied, which is in the bundle that we all have. Therefore, we are not going to ask you a lot of questions to confirm what is already there. Everybody is taken to have read the documentation, but we will seek to highlight certain points that we are of interest to us in regard to the criteria that I spoke to you about. Do you understand that?
Yes, I do. Thank you.
You hold a BUris and an LLB degree, and you worked as a prosecutor, you worked as a magistrate, and you were director at the People's Family Law for some time. You then acted as a judge, and you were appointed as a judge in 2009 in the Western Cape Division of the High Court. Is that correct?
That is correct.
And you got an opportunity to act in the Supreme Court in 2015. You acted actually for quite a long time, about a year, is that correct?
Yes,
May 2015 to April 2016.
2016.
And you went back to the Supreme Court of Appeal in December 2023, and you are still there, is that correct?
That is also correct, yeah.
That suggests that you have had a lot of opportunity to acclimatize to the work environment of the SCA and to get used to their work. Is that correct?
That is correct.
Yes. Now, let's talk about the High Court. The judgments that you have written since you were appointed for the first time as a judge of the High Court, can you share with the commissioners what branches of law they cover?
Yes. At the High Court, I dealt with matters of civil law, contract, of family law. I dealt with criminal law. In fact, every aspect of law, I dealt with constitutional issues, and a wide spectrum I dealt with at the High Court. It's been a long time that I've been on the High Court bench.
Yes, so we see the purpose for this question is just to see the breadth of your experience.
Yeah.
So you're not doing yourself a good service when you just say a wide spectrum. It's good to specify. You have specified some, but if those are the ones, that's fine. But if there are more, it's better to tell us.
Okay. Thank you. In my time at the High Court, I dealt with family matters. I dealt with constitutional matters. I dealt with contract. I dealt with criminal law. I dealt with administrative issues and interdicts, everything that happens in a motion court, sometimes back to back. I had to do that. And then literally everything every type of application that one can possibly imagine, I have dealt with over these years.
So you then acted in the Supreme Court of Appeal. Share with us the same information in relation to the Supreme Court of Appeal now. In other words, tell the commissioners these are the branches of law where you have written judgments in the SCA, and therefore they can see the breadth of your experience.
Okay. In the first year that I was at the SCA, the matters that I dealt with was also very broad. It involved issues of contract again. And this time when I went to the SCA, in fact, I was called in very late in the day, and I was called in for a matter that was allocated to me there was a 62-volume matter involving German law of contract. So I had to, when I was called up, I was busy with a criminal matter. I had to finalize that matter and then study into the German law for that hearing. Myself, I was not the scribe in that matter, but I was a member of the panel and I was thoroughly prepared and understood the principles of German law in that 62 volume in the time available to me. In addition to that, the matters that I wrote was a matter on the NCA and law of contract. There were more than one issue of contract involved in that judgment that I wrote. And further, once the matters that I did not write involved matters but where I was a member of the panel, that involved contract again. It involved the constitutional law and administrative law. Also, issues of criminal law was involved in 2 of those matters. So again, it's a wide spectrum.
Yes, thank you. May I refer you to the questionnaire that you filled and submitted to the Commission? And in particular, I want to refer you to question 16, which appears on paginated page 7.
I am there. Yeah.
You are there. 16, question 16 says, list the cases where you have written the judgment, not more than 10, which you regard as being the most significant and why. And then you listed a number of cases there. The first one is Shabros Property Investments. There you say, Networks Pty Limited, electronically delivered. The colleague seized with the matter, took ill, and the matter remained outstanding for many months. At the time, I was seized with a criminal matter, but volunteered to finalize this and other matters, as it was unclear when or if the colleague would be able to return to office. He is still on sick leave. This is an indication of a mature and responsible attitude towards the administration of justice. You see that?
Yes, I see that.
It appears to me that you are not answering the question that has been asked there. You are asked to list cases that you regard as most significant and say why they are significant. My reading of what you say there, which I've just read, doesn't seem to go to the question of why that judgment was significant. It just talks about the fact that you saw the need to assist.
Yes.
Do you agree?
Can I explain?
Sorry?
Can I explain?
Well, do you
Yeah.
agree and you want to explain, or do you not agree and you want to explain? I first want to know whether you agree or not.
I, I, I looked at it differently than you do.
Yes,
My
okay.
reason
Tell
for,
me. Yeah, tell us.
okay. This matter, we have a problem generally in the judiciary where people complain about long outstanding judgments. This was a commercial contract that's involved here, and the matter had been fully ventilated. There was a trial in this matter. Now, it's not easy to get into a trial like that and then write a judgment with, it's not an appeal. I must write a judgment as a court of first instance, not having had the opportunity to see the witnesses. And then to write that judgment and get the basic principles of the contract that was involved here correct. I thought that added to the reason why I wanted the commission to see that I'm not just somebody who, how shall I call it, just quickly do things. It was actually having to go through that record, study the record, and distill the principles of contract there. There was an initial rejection of the contract party repudiation, and then afterwards there was an acceptance.
Let me stop you there. There is nothing talking about principles of contract in that passage, isn't it?
I know, yes, yeah, that is correct.
The question was asking you to tell the commissioners to list cases you regarded as most significant and to say why you regarded them as most significant.
I
Do you
agree
still
with
say
you.
you answered the question?
Yeah. I've answered it now, not
No, no, in the questionnaire.
No, yes, no, that does not give the answer that I gave you now.
Okay, let's go to case number 3, which is on paginated page 8.
Yeah.
Poison versus merger and another. You are supposed to be a case to regard as most significant, and you are supposed to indicate why you regard it as most significant. And what you say there is this. The respondent alleged that the applicant had sexually assaulted her. The applicant approached the court seeking an interdict and prescribing to the rape survivor how she should narrate her complaint. I held that it would be preposterous to give the alleged abuser editorial rights over his victim's narrative. What do you say about that answer?
That answer is correct because.
Sorry?
I say that answer is correct. That was the importance of that case.
What is the importance of the case?
The importance of the case is that an abuser has no right to tell his victim or his survivor how they must, or he or she should narrate their experience and their harm. It is very important that a survivor of rape is able to tell their version as they see and experienced it. If the abuser is able to tell, this is how you can report it, it takes away from the power of the victim, survivor now, to tell their version of what they say happened. And that is why we often now have interdicts and trying to gag a survivor saying, you can't say that, this is how you must report your complaint. And I thought that is very important, that the survivor is given a voice of their own.
Let's go to case number 4, Ramando. You say in this matter the applicant was included in a list of alleged abusers. I held that he had the right to challenge his inclusion in the list that did not bring the validity of the list in issue. Is that right? You say that one answers the question?
I say it does because the list was an issue. At the university at the time, there were people saying that list is defamatory and the list should not be circulated anymore. This judgment dealt with one person who said, my name on the list is not warranted. And I said that that is not the judgment does not affect the validity of the list because people were standing back now and were afraid how many more of these are there going to be. And that has the effect of perturbing people coming forward because look what happens when you complain. It is necessary to say that the accuser had the right to challenge his name on the list, but that did not bring the validity of the list into question.
The last one that I want to raise.
Sorry, Chief Justice. Her voice is too soft. We are struggling this side.
Sorry?
Her voice is too soft. We are struggling this side.
Oh, I'm sorry. Her voice. Oh, okay. No, I thought you said mine. Okay, please speak up so that the commissioners can hear you. Okay. All right. The last one that I want to refer you is case number 9, on page 9, Labertus von Wille Bester. You say that the importance of that case is that you refused an application to separate a special plea of prescription from the merits. I held that the merits of a special plea of prescription are linked to the merits of the plaintiff's claim. That evidence will have to be led in the separated trial and again in the main trial. Is that right?
That is correct.
You say it answers the question.
Yes.
Okay, all right. Thank you. Justice Mullerman.
Thank you. Thank you, Chief Justice. Good morning, Justice Baartman.
Good morning, President.
I'll just continue from where the Chief Justice left off in relation to your overall experience. You mentioned that you've been exposed to a broad spectrum of the law. I know that you are from a coastal city. Have you had an opportunity to do any maritime law cases there?
Yes, I have. In fact, if you look at my list of numbers on page 10, case number 4, that was a maritime matter that I did in my first year after my appointment. Since then, I've been involved in it on urgent applications, having to arrest a boat or release. We have a lot of that in Cape Town.
Okay, thank you. And at the level of the SCA?
Not at the SCA, I have not had.
Oh, you haven't. All right. So you indicated that you were allocated a 62-volume matter that, amongst others, required you to familiarize yourself with German law. Would you say you coped? I know you mentioned that you were not described, but did you cope? Did you make a significant contribution, either in court or in your post-hearing conference in this matter?
In the post-hearing,
Yes.
there I made my contribution.
Yes.
In court, I took ill at that time, so there wasn't much contribution in court.
Yes.
But prior to the hearing, I fully was well versed in the application and understood the facts, and therefore was able to make a meaningful contribution.
Yes. So, having participated in this voluminous record appeal, did you manage to prepare sufficiently for your other appeals, Or did your participation in this matter compromise in any way your participation in other appeals?
No, it did not compromise me in any way. I wrapped up what I was busy with at the High Court and immediately started doing that. Hence, I was able to finalize the judgments that I had for myself as well.
Yes. So you acted at the SCA in 2015 and 2016, and then had a long break where you were at the High Court and came back to the SCA in 2023, I think, yes?
That is correct.
Yes, you must have realized when you arrived at the SCA that things were different in as far as the research capacity is concerned. Is that correct?
Yes, yeah, it's very different.
Yes, in terms we have limited, more limited research capacity at this stage.
Yes, you do.
Yes, and as a matter of fact, the justices, 26 justices of the SCA have had to rely on only 3 law researchers.
Yeah.
Yes, you'd agree that this would mean that a judge has to be self-reliant, largely self-reliant in terms of preparation for the hearing and also in terms of preparing the judgment.
Yes, yeah, you really have to be able to do research by yourself.
Yes, and did you manage all these tasks?
I had no problem with that.
Yes.
Yeah.
All right. And in terms of the environment, during your last stint, your most recent one, how did you find it?
The SCA has, the SCA has changed. There is a general collegiality about that was not that obvious last time. In 2015, 2016. It is a pleasant working environment, although you work very hard, but it's pleasant.
Yes, you'd agree that it is not the kind of environment that permits a lot of hand-holding, meaning that colleagues that are appointed there must be able to really hit the ground running.
Oh yes, for sure. There's no time for somebody to handhold you.
Yes. I note that you have now been a judge for 15 years.
That's
That's
correct.
correct. Okay, and prior to your appointment to the bench, you were in the legal profession for approximately 20 years.
Yeah.
Yes. How would you say this experience, your judicial experience of 15 years and the experience prior to your appointment to the bench, how has this prepared you for your appointment to the Supreme Court of Appeal?
Because you, as you correctly pointed out, you need to hit the ground running. There's no time for hand-holding. All those years of experience prepares you for that. You're able to work independently and goal-directed.
Did you have any difficulty in preparing your judgments during your most recent stints?
No, I did not.
Did other colleagues have to make extensive inputs on matters of substance?
The inputs that colleagues made was mainly of a cosmetic issue. There was no rewriting and substantive reworking of my judgments. That was never necessary.
Yes, and you have produced your judgments promptly?
Promptly.
Excuse me?
Yes, I have.
Yes. Yes, so you probably know that the SCA has lost a lot of experienced judges due to attrition.
Yes, I know that.
Yes, so in terms of your experience, what are the special attributes that you bring to the table at the Supreme Court of Appeal?
It is the fact that I've been exposed to, as I say, a wide range. When the Chief Justice asked me, I said, many matters, and he said, you're not doing yourself favors. But I've been exposed from everything that you can be exposed of at the High Court in these years. And that's literally everything from an interdict, from maritime matters to constitutional matters to criminal matters to family law. I've experienced and had input in all areas of law.
Yes, my last question is, taking from your response where you said during your most recent acting stint, you found the environment particularly collegial. You'd agree that collegiality is very, very important at an appellate court because judges sit only in panels.
Yes, you have to be able to work in a team.
Yes. Have you personally had any issues with any colleagues?
None that was not amicably resolved.
Okay. Thank you. Thank you, Chief Justice.
Thank you.
Thank you. Minister.
Yeah, thank you very much, CJ. Also welcome Commissioner Bredenbach for her maiden appearance physically at the JSC. Good morning, Judge Baartman.
Good morning.
Yeah, I only have one question in relation to the matter you have handled of the joint owners of Hardenbos versus Minister of Local Government and so forth. For sure you remember the matter.
Yes, I do.
In relations to NEMA, where do you strike the balance between compliance with NEMA and the imperative of economic developments, create jobs and so forth in the country?
That's a very important balance. It's a balance that must be struck taking into account the environmental issues that we live in, making sure that there is something to pass on to our children thereafter. So projects and the implementation of every project must comply with certain basic criteria so that a project does not destroy whatever there is in the environment. And that can be done. It's usually putting in place certain measures. And in this judgment, that speaks to the measures that needed to be in place for every activity in that project.
Thank you, CJ.
Thank you. JP.
Thank you. Good morning, Judge Baartman.
Good morning, JP.
Just one question, or two maybe, if the CJ will allow me. You're applying to sit in the SCA. I've looked at the judgments you've listed, which you regard as most important. The CJ took you through them. Are any of them full court judgments from the Western Cape?
Yes, just one.
Just one.
Yeah, I was the presider and scribe.
I see.
Yeah.
That's what I wanted to check with you, because you are applying to work in an appellate court.
Yeah.
I would have expected to see more full court judgments that you would have written, but I'm not critical of you, but I just want to check, have you sat in a lot of full court judgments as a senior judge? I mean, you're more than 15 years on the bench now.
Yes, I have. The reason for not submitting more of those is I want the commission to see what I can do on my own. And that's why I gave judgments that I wrote on my own, so that you can see this is just my work.
Yes, but even if when you are presiding and you are a scribe for a full court, you're not on your own, but you're leading a bench, isn't it?
Exactly. That's why I gave you one of those.
I see. Yeah. Okay. Thank you very much, CJ. Oh, sorry, one last question. It's just, I found it strange in your questionnaire when you refer to the OCJ, you say Department of Justice, then OCJ in brackets. Can you explain that? I'm very passionate about my independence.
No, I'm not trying to undermine the independence. It is just a matter of habit and making sure that we're talking about the same. Yeah.
We're out of their pocket, you know. We're on our own.
Yes, no, the
Thank you very
independence
much.
is very
Thank
much.
you.
But I think that what the judge president is seeking to establish is whether you know the difference between the Department of Justice and the OCJ.
Yes, I do.
What is it?
Okay. The Department of Justice is just that. It is the Department of Justice. And the OCJ is the judiciary on its own, where we belong.
Commissioner Dodovu.
Thank you very much, CJ. Good morning, Justice Baartman. You appeared here in 2018 for SCA possible appointment. And one question that was a concern about you was that you lean more towards criminal matters than civil matters. To what an extent have you addressed and improved that area? If you don't mind, can you just raise your voice a bit?
Sorry, the microphone went off. Okay. In the time that I was between that and now, I have been exposed and had dealt with so many matters of difference. You will see the matters that I even volunteered to be involved with civil matters. And when called to the SCA now this time, I was called in, as I have said before, into a matter of German criminal law and could fully immerse myself into that. So there was not a problem with only doing criminal law. You can't, in our division, specialize in like criminal law, although you have a criminal background. Yeah.
Thank you, CJ.
Thank you. Commissioner Matolo Sepu.
Thank you, CJ. Mine is just a question for Judge Baartman. I see you have done a lot of training in diversity, and you've done a lot of domestic violence matters, and you have been very, very involved in such trainings. Are you still participating in that? Or are we going to lose you to the SCA?
Sorry, the microphone goes off. No, my appointment to the SCA, if successful, would not lose me because you continue to take part and advocate these issues.
Thank you. Commissioner Marumwahai.
Thank you very much, CJ. Good morning, Judge.
Morning, Commissioner.
I realize that you seem to be quite passionate about the area of law, contract law, from your responses. And I just want to ask you one question in relation to contract law. Can I take you to page 617, I think, of your paginated documents?
Yes.
Yes, there's a judgment there, Shabros Property Investment and Mobile Telephone Networks. I see that in this, obviously this is not a test, and I'm not going to ask you about the nuances of the case, but I'm just curious about one thing. I see that in this case, you were applying one of the theories of contract law, the doctrine of quasi-mutual assent.
Yeah.
Which is probably one of the most important doctrines in contract law, and one can argue it's at the heart of contract law. And after reading the case, I'm not really sure if I get a sense of how you are actually applying it, because I can see you quote the Locus Classicus SONAP case that was decided in 1992 of the Supreme Court of Appeal.
Yeah.
Well, there is a more recent case, but that is besides the point. What I want to understand is what role does this doctrine play in the contract itself when two people are actually entering into a contract? And what is the significance of this contract if there should be a dispute?
Well, first of all, you will then, your issue is, was there a contract? Did the parties enter into a contract?
No. In the judgment, the parties entered into a
Into a
contract,
contract.
and you were resolving the dispute that arose from the contract.
Yes.
So I'm not necessarily asking you about the case per se, but after reading the case, a question came to my mind that what is the significance of this doctrine in a contract when people are actually contracting, are entering into an agreement? And what role, if any, does it play in assisting a court to resolve a dispute should one arise?
Because we don't know what happens in somebody's mind. All the court has is the outward appearances. How did you present yourself? Mislead, or what impression did you make on your contract? And that is what this doctrine, that you can't sit there and have your reservations for yourself and saying, further down the line, I'll say this was not consent. And parties are held to their outward appearance and their outward manifestation of their intentions.
Sorry, CJ, can I just
Okay.
a last bite on it?
Yeah, last one.
The reason I'm asking you this question is contract law generally in South Africa, it is on the crossroad. And there is a question as to whether you can infringe, and I'm using this quite guardedly, into common law, contract law with constitutional principles, right? And when one looks at these subjective sort of doctrines that we apply in relation to how contracts are interpreted, and this is why I'm asking you this question. In other words, what is the role of this kind of doctrine in the development of contract law in South Africa? Can we still, because the thing is, you are going to the higher court, you are going to be expected to interpret some of these contracts in line with this doctrine. So I just want to understand your jurisprudential sort of thinking around this particular doctrine, which is quite subjective, but you need to apply it on quite an objective contract. And that's where my discomfort is.
Please speak up. You
Sorry,
can keep
the
your mic on.
microphone. Yes, the
Okay.
microphone goes up. The contract is measured against the constitutional principles. You will see if this is a contract that is contra bonus mores or not. But parties in general are held to their agreements, that they must be held to their agreements. The court cannot make decisions for contracts for a party. So in finding what the contract between the parties are, the court looks at what is there, what does the document say, and then in finding that, you look at what the parties, how they manifested themselves in terms of the contract.
Thank you very much. Thank you very much, CJ.
Thank you. Commissioner Nochesi.
Thank you, CJ. Good morning, Judge Baartman.
Good morning.
Yeah. I just want to confirm one thing. As you are applying for an appellate court where you work as a team,
Yeah.
you will be in panels. Is it, would I be correct to say one of the special attributes is that you must be a collegial person, you must be respectful to all your colleagues, You must not have some superiority over others. You must be able to be persuaded in the team. Is that, am I right that that is a special attribute for a judge who must be in an appellate court? Would you agree with me?
Yes, I agree with you. You must also be able to persuade others of your view without imposing your view.
Thank you.
Thank you. Commissioner Moiman.
Thank you, Chief Justice. Good morning, Judge Baartman.
Good morning, Commissioner.
Just one question from my side, which relates to your questionnaire, where you list a judgment that were successfully appealed against you. So my question relates to the Speaker of the National Assembly versus the Public Protector.
I'm sorry, can you speak up? I didn't hear. On which page are you?
It's page 10
Page
of your
10.
questionnaire, where you list cases that were appealed against your judgment.
Yeah, which one? Number?
The Speaker of the National Assembly versus the Public Protector.
Yes.
Yes. The one of the aspect relates to that was successfully appealed against your judgment is the pronouncement that you made in relation to the inclusion of a judge in the preliminary stages of the inquiry. And from yourself, from the judgment, you said that it violated the separation of powers.
Yes.
So now, the question that I want to understand from yourself, Justice, is what are the lessons that you have learned from this judgment in relation to the doctrine of the separation of powers, particularly in relation to the role that the judiciary can play in promoting the values of our Constitution, particularly the rule of law, because my understanding is that separation of powers is not absolute. It has a role to play in our transformation of the judiciary and transformative justice. Thank you.
Thank you. Yes, it has, but the court cannot shy behind separation of powers from dealing with the matter. You will see in the matter of, there's another matter that I said, the Scalabrini matter. There the state also said, oh, there's separation of powers. The court cannot interfere with separation of powers. It was actually not a separation of powers issue. It was an issue whether the regulations were against our own law in terms of where we do not send somebody back against to the country where they face persecution. So in that process, separation of powers didn't save the day for the respondent. In another matter, it might save the day for them, but it's for the court in each instance to delineate whether we are dealing with separation of powers. Is the court overstepping? And be careful not to overstep, but not hide behind that and not deal with an issue. That's where it's sort of you've got to draw the line.
Thanks, Justice Baartman. Thank you, Chief Justice.
Thank you very much.
Sorry, Chief Justice.
Yes.
I just want the answer to be repeated. I'm not sure if I understand the explanation of the doctrine of separation of powers.
Switch on your mic. You can keep it on until you finish.
Thank you. I indicated that you have the various divisions and the court must be mindful and with due deference to the other legs of the government and not to overstep. But at the same time, the court cannot hide behind and be timid and not venture into an area when you have to. Not everything is separation of powers or intrude into that doctrine of separation of powers.
Yes, I'm still not sure if I understand. I mean, if you do have a proper separation of powers case,
Yeah.
on what basis will then a court intrude into the sphere of the legislature or into the sphere of the executive?
If you have true separation of powers, the only way that you then, you don't interfere when you say this is within that particular arm of government's jurisdiction to do that. They've exercised that discretion within their powers. Whether I like the way they've exercised it, that's not the issue.
No, I don't know if there's no confusion in concepts. The one instance is where a court is trying to give an order that is just and equitable under Section 172.
Yes.
That may or may not engage separation of powers,
Yeah.
but it is a discretionary question. The other is where a court is deciding where the law allocates a decision-making function,
Yes.
which is on the merits, not on the remedy.
Exactly.
And the problem with the answer is that it seems to conflate the two. And it seems to say there are instances where a court would be justified in intruding on separation of powers. And I'm not sure if I actually understand. Maybe the starting point is, how do you understand the separation of powers? What are the exceptions to it?
The separation of powers, I understand, is the court looks at the separation of powers will come from the case itself. You will see what are you dealing with. Is this issue exclusively in the domain of that particular actor? Did they exercise their discretion that is allocated to them? Did they extend or go over what they were supposed to? Were they able to implement their particular decision within the powers allocated to them? Once that is the question, that is, if that's the finding, that this is a power for you, for that particular actor, they've acted within their power. Whether the court likes the result or not is then not the issue. It's judicial, it's within the Constitution, it is a decision that could be taken.
Thank you, Chief Justice.
You referred in your answer, talking about separation of powers, to, I think, Commissioner Muiman, to legs. What was that about? I just want to make sure I understand.
It's a different arms of government.
Arms, yes.
Arms, not
Okay.
legs. Yeah.
Let me put these questions. You want to share with the commissioners your knowledge of what the rule of law is?
Yes.
Yes, please go ahead.
In terms of the rule of law, it's the legality of everything we do is derived from the rule of law. It infuses what we do. Legality and the rule of law goes hand in hand. To be legitimate, you must draw it from some source of power where you get that legitimacy from.
Is Is that the full answer?
That is my answer.
I don't see any further hands, so, and from
There's
the
a hand
commissioners. Oh,
I'm so sorry, Chief Justice.
yes, please go
Just-
ahead, Commissioner Pillay.
Two questions, Chief Justice. Good afternoon, Judge. Good morning. Judge, may I ask you a question on your Shabros judgment? It's at paginated page 17 of your pack. Now, when I initially read your judgment, like the Chief Justice, I was a bit confused about why you selected this judgment for inclusion in the pack. The dispute in that matter seemed to be a very simple and straightforward one. It was around the existence of a partly written and partly oral contract. But when I read your judgment, and particularly when I got to paragraph 36 of your judgment, what confused me was your handling of the onus in that matter. So in the lead up to paragraph 36, you deal with some principles of contractual interpretation with reference to the Cool Ideas judgment. And then in paragraph 36, you say the following. You say, and I'm reading on the third line of paragraph 36. You say, I am persuaded that the plaintiff hasn't met its onus in proving the existence of the parking lease as pleaded, which is fine.
Yes?
And then you say the plaintiff's version is true and accords with sensible commercial practice.
Yes.
And then you say the defendant's version to the contrary is rejected. And what interested me is the footnote there, footnote 4, which is the National Employers General Assurance case. And that's locus classicus for a contrary proposition. And that is when the probabilities are evenly balanced and you can't make a decision on the credibility of the witnesses, that you then make a finding that the plaintiff has failed to discharge its onus. So I just wanted you to explain this finding that you're rejecting one version and finding that the other version is true in a contractual context, and then using a locus classicus for a completely different proposition.
Yes. That locus classicus tells you how you deal with it when you can't decide. Therefore, I reference that because actually I find against that, but I have considered that principle, and that was the argument that people were making. And I was saying, no, this is actually not in line with that.
Sorry, Chief Justice, can I just make one more follow-up on these points of contract? I just want to just make sure that in the deliberations, I have a sense of your grasp of these concepts and what you will do on appeal. There was a debate you had with Commissioner, one of the commissioners, I can't remember now, around contract. It's triggered by the discussion we're having now with Commissioner Pillay. Maybe I should ask it differently. Can you set aside a clause in a contract because it is unfair?
You have to see whether the contract, you can't make a contract for parties. It is not for the court to say, this is unfair, you bargained a bad deal for yourself. The court cannot do that. You can only set aside when that term or contract itself is contra bonus moris, that's a different inquiry. But the fact that you've made a bad deal, the court cannot sympathize with you and then set it aside on that basis. No.
Thank you.
Sorry, Chief Justice, just the objection, if I can just put...
Yes, yeah. Okay, please put the objection.
So, Judge, it was drawn to your attention that an objection had been raised with the Commission by a litigant who had appeared before you. I think it was in a matter, you were presiding over an application to compel compliance with an earlier court order.
Yes.
And you granted default judgment in the absence of the litigant being in court.
Yes.
And the litigant has raised an objection that essentially says that you acted irregularly, Judge, and to just distill the objection, that questions are raised around whether or not you acted ethically in that process. I just wanted to give you an opportunity to respond to that.
Yes, that matter is now before the SCA, but I will deal with the matter and have dealt with it. It came to my attention late Friday. In my response, there's a letter from Advocate Brink explaining the long history with this particular litigant. This is a family issue and siblings fighting over a house, and one party deliberately trying to delay the process. When the matter appeared in front of me in the urgent court, there was a valid judgment, enforceable, no appeal against it. She was properly called to court, absented herself, which in the address to me was in line with what happened. And I put into operation the enforceable order that was in place in any event.
Thank you, Judge. Thank you, Chief Justice.
Thank you very much. Commissioners on virtual, I have...
Chief Justice, I just want to tell the judge that the Objections Committee dismissed the objection against you.
Thank you. There's no indication from the virtual platform. Thank you very much, Judge Baartman. We have come to the end of this interview. Once again, thank you for availing yourself. You are now excused.
Thank you.